Hello, welcome everyone. My name's Yildiz Batez and I'm one of the directors on the board of the South East London Chamber of Commerce and also a partner at Thackray Williams. I'm filling in today for our President Helen McIntosh, who's unavoidably engaged on other Chamber business and sends her apologies. Just to remind you that the Chamber supports all businesses in the 5 boroughs of Bromley, Bexley, Lewisham, Greenwich and now Croydon, and you can visit our Chamber website for more information. We run regular webinars on topical legal issues for our members and prospective members. And today we are going to learn about the key things startups need to know when starting up a new business. Starting a new business is both exciting and thrilling. And nobody wants to dampen anyone's enthusiasm, but getting a few insights from today's expert legal panel will help prevent making some expensive mistakes. There'll be time for questions at the end and we'll ask you to raise your electronic hand when you want to ask a question. Today we have Dr. Saverio Salandra, otherwise known as Savvy, who's one of my partners at Thackray Williams and heads up the corporate department at Thackray Williams, specialising in business transactions with many years of experience. He also specialises in all aspects of corporate law, banking and finance. With him today is May Chung, our corporate solicitor. Within her role, May works with a wide range of clients from individuals to national businesses. She offers strategic direction and guidance to help clients achieve the outcome that they require in the way that best suits them best. Both appreciate that the legal process and contractual terms can be quite technical and daunting, and both aim to provide comprehensive legal advice in a way that can be easily understood. No mean feat. So without further ado, I'll hand you over to Savvy.
Hi, Yildiz. Thank you very much for the introduction. Thank you very much for everyone for joining us in this webinar. I would like to give just a quick introduction of Thackray Williams. We are a law firm, Legal 500. We have offices in London, Bromley, Sevenoaks and West Wickham. We are a full service legal law firm. So we cover pretty much everything from wills, tax and administration, family law, dispute resolution, employment law, residential law, real estate, commercial property, and of course, corporate finance and banking. For what concerns corporate banking and finance, my department, we cover everything from the startup of the company until possibly an IPO. We do merger and acquisition, shareholder agreements, finance and growth funding, joint venture. We advise on insolvency, restructuring of the company, and any kind of commercial contracts, franchise agreement, business startups, and intellectual property. So we are here today to talk about startup business. So usually, the first things that we need to talk about when we start up, when we have a startup, when we are starting the business, it's which one is going to be our business structure. So usually people, they tend to start their business and be like what they call a sole trader. So basically they don't have an entity, a legal entity as an LTD or a limited partnership. And they just start to trade under one name. And usually they're responsible for the liabilities that they are going to incur during this process. Another way to set up your business is, example, when you have a partnership. A partnership can happen automatically wherever you and your friend they start the business. You start to trade under one name. You start to share profit and losses, and of course there are some kind of liability that are going to be still attached to the two people that are still not a legal entity as a company. A way to try to mitigate this kind of liability is to set up a corporation, a company that can take various forms. Apart from a partnership example, you can set up a limited liability partnership, LLOP. That's a separate legal entity. So a partner is going to be liable only on the amount that he has invested in the business. The company is going to have a company house number, so it's going to be registered with the company house and HMRC. And all the members are going to profit basically and share from everything that is arranged and described in what is called a partnership, LLP partnership agreement. The common way, and this is usually the structure of a limited liability partnership, usually used by example, accounting firm or law firm, professional firm. The most common way to separate the legal entity of your company and so also the liability is to set up a limited liability company. So basically, in a limited liability company, you have other people that are going to be the shareholder or members of the company. You are going to register your company at Company House, where you are going to receive a company number plus what is called a model article for the company. The company can be limited by shares, example. So basically, the responsibility of the shares of the company and the shareholder is going to be limited to the amount of share. For example, if you have 1,000 of share issued for the company for £1 each, so basically means that you are going to have a share capital of 1,000. That means that that is going to be the liability of the shareholder in the company. Or the company can be also limited by guarantee. So, example, every member agrees to pay a set amount for the company debts. Usually, the company are subject to corporation tax. And then again, they can pay dividends to the shareholder every 6 months, years or so, as it is going to be defined by the article of association. Now, usually the founders, where they start a company, they really need to think about a lot of different matters. We understand at the start, we are very, very excited and we want to start a company, and then we want to start a trade because we have this great idea and there is probably some kind of market, target market that we already have in mind, and there is a niche market that we want to approach as soon as possible. But we should start to think about where we set up our business, as we were saying, which one is going to be the structure, because that is going to be also what is going to create the future of your company. Example, if you're going to structure the company as an LTD, then again, probably maybe you can have other people that you want to take on board later on. Maybe they can be like as a consultants of the company, so not really employee of the company or employee of the company, or you would like to have some other partners or shareholders or investors that are going to join the company. You need to think about, example, if you're going to give some shareware, for how much share you're going to give it at the start of your business, or if you would like to wait and then give share later when actually the value of the business is much higher, how you're going to have the control of the company, how you're going to take money from the company. So you're going to have, example, some director salary because you're going to be director of the company. Are you going to have some assets in the company? Now, as we were saying before, most of the, if you set up a company like a limited company, most of these issues can be found in what is provided by the company houses, the model article. Now, every company needs to have an article of association by law. And of course, the copy of the article of association that is given by company house is going to be probably suitable for one person, the model article, one person company, but maybe cannot be suitable for more than one partners. So usually there are different ways that you can amend your article of association. Example, you can have the default model article and amending based on the model article, or you can have use only the model article without amendments, or you can have a bespoke article. It's basically something that is going to be start completely from scratch. Now, speaking about the model, the article of association that can be bespoke model and should be registered anyway, anytime with the company house, we need to take in consideration that there are going to be it is going to be, first of all, a public document, and is going to usually govern various kind of areas that are going to be part of the business. Example, they're going to regulate the classes of share and the rights attached to any class of share. Some class of share can have rights to dividend, but not to capital, or they are going to have voting right or not voting right. You can have, example, two classes of different share, like A and B share, and so you can manage different kind of rights attached to it. There are going to be some kind of procedure in the article association that are going to involve the issuing and the transferring or transmitting of share. So how you can issue share, if there are going to be some permitted transferee, example like your spouse or your children. Often it's going to regulate also what is if the company wants to buy back some share. Let's say that some of the shareholders is going to leave the company, and then you would like to buy back the share of the company, if the company can buy back the share. And of course, there are some kind of investment criteria, and there are some kind of criteria that need to be followed to be able to buy back some shares. So the company should be prepared for it. There are going to be all the procedures that generate and usually are going to give you rules about how you are going to hold the general meeting, how you're going to have a board meeting of the directors, how you're going to appoint directors, how you're going to remove the directors. All these kind of procedure and provision that usually are not in a model article can be bespoke in an article of association. Example, you can also draft a drag along and tag along rights. Example, a drag along is when the majority shareholder can force the minority shareholder to sell their share on the same term as them. So let's say that at one point the majority, 70% of the shares, receive an offer from a buyer, from an external buyer. Then you can basically drag the minority shareholder and you can basically sell the 100% of the company with this kind of provision. Or it can be a tag along that is going basically to trying to protect the minority shareholder, because maybe the minority shareholder, they started the company with you, but if you're going to sell your 60% or 70% of the company, maybe they will not like to work, or they will not like to be member or shareholder with the new shareholder. So at that point, they have that what is called a right, is tag along right. So basically they can tag along with the majority shareholder and sell also their share. So this is basically what, and of course, what is can be covered by the article of association. Most of the company we suggest all the time, apart from having an article association, as we know, it's a public, it's a public record, so it's going to be in company house. You can go a little bit more in details when you set up a company. Example, you are two people, having a shareholder agreement in place. Shareholder agreement in place basically is going to organize and rule all the procedures that are going to be between the shareholder themselves and the company. At the same time, the fact that is a private contract, basically, doesn't need to be registered in company house. So basically you can put also some kind of more sensitive information that you will not like to include in your article of association. And it can provide a kind of a level of protection for damages or any kind of coexistence between the shareholder that you cannot find in the article of association. For what concerns the matters that usually we try to cover in a shareholder agreement, we can talk about dividend policy. What kind of decision, example, require shareholder consent, and at what kind of levels. Example, you can say that if for whatever reason you own a property in a company, and there is the opportunity to sell the property without having the majority, example, of the shareholder approving the sale of the assets, you can have this kind of matters that require unanimous consent. So example, even if I have 1% of the share in a company, but we need to sell an asset of the company, if there is not unanimous consent, 100%, that we cannot sell that asset of the company. You can cover in more detail how to issue and transferring the share between the permitted transferee. And of course, all the right and obligation of the directors. And then again, if you have two different kinds of shares, which directors can elect other directors, the majority of the board, who is going to have more director and so on. And this is, of course, a really, very important part of a company and the life of a company. And this is what is going to regulate the future. And during the stage of the life of the business, usually you tend to change your article association to meet your needs. And same the shareholder agreement. That's why it's very good to have every time an updated version of the shareholder agreement, because your needs are going to change over time. The needs of the investor, the people that are going to be part of your company later at a later stage, are going to be different from the needs of the investor, the people that were at this stage. Other things that we need to take in consideration also when we open a company is it's a very important thing. So usually this is probably one of the first things that we think about is the business name of the company. And of course, we need to find a business name that we like, but at the same time, we should make some kind of due diligence of the name, especially if there is any similar name in business already, it's training already. And then again, because there are also some kind of other matters attached to it. And I would like to leave on this topic the word to May, that she can talk about a little bit more in detail about business name and the intellectual property attached to it.
Thanks, Avi. So you can say choosing a name for your business is like choosing a name for your child. Your first impression is going to count. Your business name should help you build up goodwill amongst your customers, suppliers, and employees. And if the business is successful, it could become a valuable asset. Choosing the wrong name may be bad for marketing, but it could also lead to legal troubles. So what should you take into consideration when choosing a business name? You should choose something that's distinctive and unique. So choosing something distinctive and unique can be stronger for brand recognition, and it can also be easier to trademark. You should also aim to choose something that doesn't restrict your business's growth. The name should work well for your startup now, but also work well 10 or 20 years down the line, or when your business has global reach. You should also check for availability. You need to do your research before deciding on a name. You can search Companies House, trademark registers, domain name websites, and search engines. Your company name or trading name can't be offensive, and it can't be the same as a registered name or a trademark. And it also can't suggest a link with the government or local authorities unless you have prior approval and you meet the relevant requirements. You can also protect your business's name by registering your business at Companies House, and also by registering your name as a trademark. By doing this, others won't be able to use your name or use something similar to your name. There are certain risks of choosing the wrong name. The first one being market confusion. So your brand could be confused with someone else's brand. There's also wasted time and costs involved. So you've spent so much time and effort, you've expended so much money in building a brand. If it is confused or infringes someone else's brand, you could be spending those time and costs again in rebranding. There's also the risk of intellectual property infringement. So someone could try to sue you for trademark infringement. These claims are costly and time consuming. So you'd rather spend your time building your business rather than defending any claims. You should also think about contracts for the business and third parties, for example, suppliers and your clients and customers. It's easy for startups to rely on terms and conditions provided by suppliers or on oral contracts or key terms agreed by email or phone, but taking the time to put in place written contracts can be beneficial. Let's have a look at why your business should have terms and conditions. A written contract can clearly set out each party's rights and responsibilities, providing a better mutual understanding of what is expected from each other and the business relationship. A clear set of terms and conditions can help provide certainty and be easier to enforce. For example, terms and conditions will often set out payment terms, including what happens if the client doesn't pay, what actions you can take, whether interest is chargeable, and what other remedies are available to you. On the flip side, if you're late in providing services or delivering goods, what rights and remedies would a client have? In the event that something goes wrong, having these terms set out in the contracts can help avoid costly and time-consuming legal disputes. Fixing a problem is often more expensive and more time-consuming than avoiding it in the first place. There may also be legal obligations that you have to comply with depending on your industry, the type of customer you provide products or services to, or even how you sell your products and services. So setting these out in the terms and conditions can help you ensure that you meet your legal obligations. Having your own terms and conditions can also help ensure consistency and good customer service. There are no surprises, and an agreed set of terms can help manage expectations. For example, the contract may set out circumstances in which you can't meet delivery or performance within the time specified. So having terms such as insurance, refunds, or how complaints are handled can also help reassure a client. So T's and C's can also help limit risk and liability, protecting your business and its reputation. Terms and conditions will usually cover commercial terms such as payment and delivery and performance, but they can also go further than that. They can limit any liability for any delay or failure to fulfill an obligation, for example, as a result of an event outside of your control. So it's important that you have terms and conditions that you actually understand and that are bespoke to your business. So these are the common terms that you'd expect to find in terms and conditions. First one being product or service to be provided is usually a description, and it specifies what exactly it is to be provided or delivered. Payment terms, so this could include when payment is due, how payment is made, what happens if payment is not made, and whether prices can be changed from time to time. Delivery and performance, obviously when is delivery and performance due, what happens if it doesn't happen. Term and termination provisions, so how long can the contract last? Can it be terminated? What happens on termination? Risk, liability and assurance, so what happens if a service or product is not as expected? How are inadequate services or products defined? And the most important term would be the limitation of liability, so to what extent would a business be responsible for any defects or inadequacies? Dispute resolution will also be important, as going to court will be costly and time consuming. So would you rather settle any disputes privately, quicker and cheaper? And finally, governing law and jurisdiction. So which law and which courts will govern the contract? These are just common terms, but obviously there will be others. These can be, but these are points to consider when you're first preparing your contract. Other common contracts for startups or documents include confidentiality agreements. These are otherwise known as NDAs. These are agreements that require a party to keep certain information disclosed confidential and to use that information only for the particular purpose for which it's disclosed. A lot of businesses these days are also online or e-commerce businesses, so it'd be useful to have terms of use for access to and use of a website. This sets out the rights and obligations between you and the website user and covers, for example, ownership of the content, acceptable use of the website content, use of cookies, liability disclaimers, and also registration and security procedures. A privacy policy is also useful as it covers how customers or clients' data is to be used, disclosed, or managed. As an entrepreneur, you may also be taking over a business, so a business purchase agreement will be useful. This document covers the purchase of shares or the assets in a business and usually includes details of the seller and buyer, the specification of the shares or the assets, purchase price, warranties, representations, and limitations on liability. And then finally, there will be a lot of upfront costs in setting up a business, and you may need funding in the form of a loan. A loan agreement would be useful, and this will set out terms and conditions on which a lender is prepared to make a loan to a borrower. And this will usually cover the loan amount, repayment terms, interest, security, and obligations of each party. So running a business means you often wear many hats. Not only are you expected to know a lot about your field, but you're also suddenly expected to be experts in law, accounting, HR, marketing, and so on and so on. For those starting a business for the first time, this can be quite daunting. Set out on the slide here are just areas in law and accounting that would be relevant for a startup. So corporate law for setting up the business and any shareholders, partnership agreements, articles of association, commercial law for terms and conditions, for example, employment law for your employees, your workers or your consultants, intellectual property law for your trademarks, for example, property law for any physical location a business needs, or any offices or shop space, and tax law for obviously taxes. A startup will often have limited funds, so it's important to budget and plan appropriately. A business plan can also help with getting funding in or investment. Cash flow can determine how successful the business is. Keeping track of expenses and expected income can help you plan better. And then finally, depending on how your business is set up, certain accounts and statements will need to be filed at a company's house. If you're not taking on employees or workers before, accountants can be there to help you with stuff like payroll. So these are just the areas that lawyers and accountants can help with. You may need other advisors in your business to help you fill other gaps in, for example, hiring or industry-specific knowledge. So why have specialist advisors? The most obvious reason is that a specialist advisor can help bring expertise and experience that a business may not have. An advisor can quickly address and resolve any issues in the business and the business that the business owner is struggling with. They can also bring a specialized skill set, an outsider's perspective to the business, and can also bring to the table new or innovative ideas that the business owner may not be able to see themselves. A business owner should focus most of their efforts on running and growing a business, but in reality, they get pushed and pulled in all different directions. So delegating projects outside of the day-to-day management, for example, one-off projects such as raising finance, can actually be really effective and time saving for founders. Smart entrepreneurs will also seek professional advice early on and work collaboratively with their advisors throughout the life cycle of the business. This helps to build a solid foundation for the business, and in the long run, it will make getting investment in and growing your business and eventually selling a business a lot easier and more attractive. So how can Thackray Williams help? So Sevi and I are corporate commercial lawyers, and we cover all aspects of corporate commercial law from for the business, from a startup all the way to seasoned businesses and, as Sevi said, IPO. So set on the slide here are just examples of what we can help startups with from a corporate banking and finance perspective, and also from a commercial perspective. If there's anything that we can help you with, please feel free to get in touch with us after the presentation. Thank you for listening.
Okay. Thank you, May and Savi. That was really informative. And yeah, I definitely would advise entrepreneurs to appoint their legal advisors very early on, because there is so much ground to cover. So let's see if anybody has any questions. While we're waiting for hands to be raised, I've got one particular one, which I think is probably important to a lot of startups, is, you know, how do I go about getting funding for my business? Because that's going to be one of the major first projects that anyone will be taking on.
Yeah, so there's two main ways that money can be put into a company, for example, is either by loan or by equity or by purchasing shares. So loans can come from yourself as a director of a company, for your family, from your friends, from your high street banks or other institutional lenders. So you can also look to people like angel investors or venture capitalists, or even through crowdfunding. So this type of funding is usually in exchange for shares in the company. There's also other types of funding that can be useful for startups. So, for example, equipment loan financing. So there's loads of different ways you can get funding into business. You just have to think about whether you want it as a loan or in exchange for ownership of the business.
Okay, and you know, obviously, a lot of entrepreneurs would have given up their full-time jobs to start up a new business. So, you know, how would they go about paying themselves, and when are they likely to be able to pay themselves from the business?
So it ultimately depends on how your business is structured. So as a sole trader, you get to keep all your profits, subject to tax, of course. In a partnership as well, you're also self-employed, so you get to keep all the profits subject to tax. But there may be circumstances in a limited liability partnership where you can also be an employee of the limited liability partnership. And then finally, as a company, you could take a salary as a director, but you could also take dividends out as the shareholder. But with one of the benefits of the company is that profits can be retained in the company. So you don't have to take out all the profit you made in that one financial year. You can kind of keep it in the company until you're ready to take it out, and take out small bits at a time over a longer period of time.
Okay. And when you're starting up a business, can you explain what type of contracts they'll need to have in place to get going?
Yes. I mean, the first things, as we were talking, I mean, you need to think about when you open a company about a circle, and every time that you do something with the company, with a third party, you should have a contract in place. There's no way that there is a family or friends or someone that I know from when I was in the kindergarten with him, but you need to have something in place that is going to regulate how you're going to react with this person. Example, in the first things, I'm going to have a partner, then I need to have an article of association, a shareholder agreement in place. Then what is the next things? Well, I have a friend of mine, he's helping me and he's working with me. I need to pay him. How he's working with you? He's going to be an employee of the company. He's going to be a consultant of the company. So then you need to have an employment agreement in place, on a consultancy agreement in place. Then you need to think about, example, okay, I'm renting now a place. I'm going to rent a place. I need to have a lease in place, a lease agreement in place. Other things, then you start to go a little bit out. Okay, you have the premises, you have the partner. Now I want to sell. Then when you need to have a term and condition in place, or something, a service agreement in place for the service that you are going to provide to someone else. So that is going to regulate, example, your liability, your exposure, exactly which kind of service you need to give to them, or example, how you can terminate the agreement, and so on. Then to be able to provide the service, you should have also a supplier. Then you need to have a supplier agreement in place that is going to create that kind of Bible between you and him, and how it's going to regulate your commercial relationship. And Then after, of course, depends how you are structured. Every business is different. So there are few kind of contracts that are pretty much standard for each business. But example, if you're a business, especially now taking consideration COVID, etc., and as May was talking, and you are going to trade most of the time online, then you need to have, of course, you need to give much more importance to any kind of clause or contract, privacy policy, cookie policy, and data privacy, and so on, because you're going to maybe to collect some of the data directly from your website. And other agreement that probably at the start, as May was saying, that you need to have in place, I mean, when you start up a company, usually the first things that you do is asking like money from friends or family. It's good to have some contract in place that can be like a simple contract, like a promissory note, where I'm promising you that I'm going to repay you X day, etc., or maybe a loan agreement if it's going to be a friends with a repayment date, with an interest if it's going to be applied an interest. So I would say these are basically the startup point contracts that any kind of business should have at the start.
And can you explain to everyone what an NDA is and how and when they should be using that as well? Because I think that's probably one of the first things everyone asks for is an NDA, but not everyone will know what it means.
Well, an NDA usually is a non-disclosure agreement, a confidentiality agreement. We suggest to have an NDA every time that you're going to expose some confidential information of your company, or maybe even of an idea. Still, you don't have a company and want to open a company. I'm looking for a partner and I have this fantastic idea that I want to sell, I don't know, ice in the desert. Now, I have a way how to do it, but of course you need to be aware that maybe you're going to provide some information that can be even a patent information to someone else, and that you're not going to be protected by that. So that's when come in place an NDA and confidentiality agreement. Then again, sometimes confidentiality agreement can be mutual, because maybe we are going to make like a joint venture or maybe a partnership. So it's going to be disclosure agreement is going to be, they're going to have some clause when basically everything that I'm going to disclose to you is going to be confidential and vice versa. Then again, example, you can have some third party that are going to be part, or they're going to be interpolated during this process of trying to establish a relationship. So maybe I'm going to introduce you to my supplier in China. Then again, it's good to have some kind of non-circumvention clause in the agreement, because yes, they're not going to maybe tell anything about your agreement, but maybe they can use partner parties that you introduce to them. So that's why it's good to reinforce some confidentiality agreement or NDA with a non-circumvention clause.
Okay, and I think obviously, sorry, Ed.
Oh, hi. I was just going to say, we've got a question from Laura waiting in. If you just wanted to bring your attention to that.
Okay, I can't see the question. Can you read it out for us, please? Sorry.
No, it's not. I'm going to unmute Laura. Are you there, Laura?
Okay.
Yes, I'm here. Thanks for unmuting me. I've got a couple of questions. The first is, what should startups look out for when selecting a law firm that they decide to work with?
Yep. So one second. When selecting a law firm, you just need to find someone that you kind of gel with. I think that's quite important. So you don't always have to go for someone who's the cheapest, or someone who's closest to you. It's important to find someone that understands your business, understands your needs, and can offer kind of holistic advice. So, for example, for us, we're more than just a corporate commercial team. We've got employment, commercial property, private client for setting up your wills and succession planning, and all sorts. So we're a firm that can provide kind of a full service for you. But obviously you need to look at someone, you need to just find someone that you kind of click with and that you understand, and who kind of is able to work with you. They're not just providing one bit of service, they're able to work with you over the longer term.
And I will also add, I mean, it's a kind of a special relationship, especially between the startup company and their lawyer. So it's good to have like, a lawyer that you're confident with, but actually you have that kind of chemistry with the lawyer too. So it's good, like, every time, I suggest every time our clients not like to take any initiative without talking with us. I mean, sometimes having a call doesn't cost anything, but we can direct the person in the right direction. They're not just getting a decision without taking in consideration the example for whatever reason you need some some money, you go to the bank, you're going to have a loan agreement in place, and they're going to give you another piece of paper to sign. It's called a personal guarantee. And then again, you're going maybe to waive even to receive an independent legal advice. And then you receive your money the next day, there's going to be like your 50,000 we're looking for. Now, what did you sign? There was this small piece of paper, there was a personal guarantee. Basically, it's going to get out all the liability that you were trying to put under a shell that was the limited company against you and your personal assets. So if later on your company is not able to repay the loan, then you're going to suffer that and repay that as a guarantor with your personal assets.
Sure. My second question then is, let's say, I know that you covered on different types of contracts out there, including the NDA. And I'm actually thinking that I might need to engage a legal counsel when I need to have a contract that define IP ownership rights. Let's say I'm trying to develop an e-commerce website and I need to ensure that the IP associated with that e-commerce is protected. In that case, can I just work with your firm, let's say, on this particular project? And if so, could you tell me how the legal fees would be structured between a client and the firm?
Absolutely. Usually, so in this case example, when we speak about intellectual property, there are different kinds of intellectual property. They can be a trademark, they can be some copyright, or they can be patent. Sometimes what the client thinks is not exactly what needs to be done. So usually we like to have a conversation, a phone conversation. We don't charge for the conversation, but we would like to understand exactly which one is the matter that we need to address. When we are able to address a matter and there is a scope that we can define, example, we would like to register a trademark. I want to register a trademark because I like my name, it's going very well, I don't want anyone to take my name and I want to protect it. Then we give you basically a fee quote, sometimes can be a range, example, between X pounds to Y pounds, or can be an already capped quote at one price. If there are any kind of additional work, then we always ask you, and we ask you, look, there is this kind of additional work, and we ask your permission to take any kind of additional work that needs to be done. So we try to give you already, especially this is very important with startup company, we cannot you cannot be exposed to the possibility that maybe tomorrow you're going to end up with an invoice that was like, I don't know, 6,000, 7,000, you were not expecting that because you were just drafting an NDA. But it's good to have some kind of a quotation that actually we put after in writing when we send you our client card letter with the term and condition. We send exactly what we're going to do for you and how much we quoted for that.
Okay, that sounds reasonable. And so final question for you. Thanks for answering my questions, by the way. So let's say I've developed a contract template with Thackray Williams, and I'm using that repetitively with my customers because I've got the terms and conditions set. And I've established the terms, so I'm using that repetitively. However, if I come across customers that want to modify or amend the terms, then would I be reaching out to Thackray Williams for that particular customer to request the review of the exceptions and have it reviewed by the counsel?
This is something that happened quite often because, most of the time, the agreement, we try to draft an agreement that is going to cover everything, etc., etc. But then again, it depends from the clients. Maybe you're going to have a huge clients. And of course, it's every time it's a kind of a power between who needs who. So if you're going to have a huge clients, say, well, actually, your term and condition are fine, but I would like to amend this, this, and this. It's very good to come back to us and ask, look, they were asking to amend some agreement. They have some amendments in place for the agreement. And then again, we can give you an advice. Look, in this way, you are going to have some liability that before you didn't have, etc., etc. Or we can work with the lawyer and the other lawyer and to try to negotiate the terms that want to be in one way amended. And then we will quote, of course, if there is any kind of amendments that is an heavy amendment to be done, we'll quote accordingly. Or if it's just like a friendly chat about amending some agreement, then there is no cost involved. It's just a friendly chat where you can call us and say, well, it will be good if I'm going to amend the agreement, example, with this company, but they would like not to pay monthly, but they would like to pay every 2 months. Well, of course, you need to take in consideration that cash is king. in business. So if you don't have enough money to pay, then of course you're going to have problem later on. But if there is any kind of amendments we can do for that for you as a Thackray Williams, and we are more than happy to bespoke if need to be done by each client that you're going to interact with.
Okay, thank you.
You're welcome.
Yeah. Any other questions from anyone? Just coming back to the PG point.
Hi, sorry, I don't know if you can hear me.
Oh, hello. Sorry, go ahead.
Oh, sorry. Yeah, my name is Aggie. Thanks for the presentation, first of all. Just a question, I guess. What are the most common kind of legal wranglings or legal obstacles that startups face that you see? You know, this is, I guess, kind of a broad question. Personally, I'm going to go into kind of the online retail space where, you know, it'd be B2C. So, I mean, yeah, if you could answer that in general terms, and then maybe more specifically, that'd be fantastic as well. Thank you.
Yes. So, May, would you like to answer, or I can answer?
Oh, I was just say generally, you just need to kind of think of how you're going to do your business, who you're working with, and you know who your customer is going to be, how you're going to kind of govern the relationship between that. I'd say one of the most common kind of mistakes or issues that we often hear about is someone taking someone else's or borrowing someone else's terms and conditions online. So some of our customers, unfortunately, or clients, unfortunately, they kind of borrow someone else's terms and conditions. So say, for example, if you're an online auction site and you borrow the terms and conditions from another really famous online auction site, that can lead to a couple of problems. So first of all, it's copyright infringement. So you really shouldn't be using their terms. And also it won't be adapted to your business. So they might have, because they're a much bigger company, they might have wider liability for exposure or whatever it is that they're able to kind of take the risk of, but a small business might not have. So one of the big problems is terms and conditions and just kind of generally not thinking that they need them. So especially if you're working with friends and family, like we often see people going into business with their friends. Oh, you know, I've known them since secondary school, whatever it is. We don't need any terms in place. And then next thing you know, a month later, they absolutely hate each other. They've ruined the friendship and they've ruined the business. But there's nothing in place that can kind of resolve any disputes between them because they don't think they need any agreement in place in the first place. But yes, Avi, what do you think? Like, what do you find that people?
You know, I agree. And then again, it depends really from the kind of business. If we're talking about retail, probably you're going to have like the kind of a rent lease agreement in place. Then you need a lawyer to look at it. Probably you need to have some kind of insurance in place because something can happen in your shop, or in a shop, somebody's going to hurt. Then you need to have an insurance. Then you need to regulate exactly how you are going to work with your employees, if they're going to be employment contract, consultancy contract. So how is going to be regulated, that kind of relationship? So, and then again, the relationship with the suppliers that are going to get you the product. So they're going to have some agreement in place, then you need to check the agreement, or you need to have an agreement. Of course, it's every time better to be the one that give the agreement, because example is going to be pro customer and not pro supplier, if the supplier is going to give you the agreement. So these are mostly the agreement that you need to have in place. As I said, every time that you think in a business that you are having a relationship with someone, you need to think about, should I have a contract with this relationship? And because things can start very well, but then can go south. It's like when people get married. When you get married, you are going to get married for because you want to get married for the rest of your life, of course. But then again, there is a high rate of divorce. So that's why you're trying to prevent what's going to happen in a divorce. It's a kind of a prenup contract that you have with your customer, of course, and your supplier or any kind of third party.
Yeah, and just to touch on a B2C point, there's a couple of factors that you need to take into consideration there. So it may be worth just contacting one of us afterwards, and maybe we can talk more specifically about your situation.
Okay, thank you, May. Thank you, Savi.
Super, thank you so much. I'm actually getting married in September as well, so maybe I'll take this advice into it.
Well, we do prenups as well.
That was not my goal. I mean, I'm sure you're going to be a happy couple maybe for the rest of your life. But I mean, based on that, actually, I mean, another things that just to be very short. But then again, if we talk about corporate, it's very vast argument. We can speak like until tomorrow. By example, another thing that usually couple or married couple tend to do, it's example, giving some of the share to their spouse of the company for tax reason, because so they can have some kind of different kind of allowance, etc., etc. And what I don't find so quite often in shareholder agreement is any kind of provision in case something is going to happen, a proceeding, divorce, etc., etc. That actually you can even bespoke in that way the agreement. So sometimes you can get like a tax example or a tax advice for what concerns accountant, but it's still very good to reflect that in the agreement. That's why we were saying shareholder agreement, they change over time, they transform over time, the same way that you are transforming. So what was important for you at the start of your career, at the start of your company, it's not going to be important for you maybe in 20 years' time. Example, in 20 years' time, maybe you want to give up your share to your partner and not exactly to your family because your kids, your son doesn't want to work in your business. So example, you can have what is called a cross-option agreement in place. And if one of the partner is going to pass away, we hope not, but if it's going to pass away, then the other party is going to have a kind of a call option over the share of the family that is going to inherit the option. And at the same time, the other party is going to have a put option. All this cross option can be regulated in agreement and then attached to some kind of insurance. So basically, the partner is going to, the remaining partner is going to achieve a sum from the insurance company, is going to be able to purchase the share from the family of the deceased partner. In that case, it's going to be a win-win situation because we are still going to have the control of the company. At the same time, the family is going to be provided with some money after the partner has passed away. That's an example.
Okay.
Thank you so much.
Any other questions?
There is a raised hand from Laura again.
Yeah, May, thanks for sharing your perspectives on Addy's question. You mentioned about startups borrowing the terms or referencing other companies' terms and conditions when they're starting out. And that's what I've been, not that what I've been doing, but I have been looking at the company's terms and conditions for the reference purposes. So let's say if I reach out to Thackray and Williams, going back to the e-commerce website example, and I share, hey, these are the terms and conditions that I like from this website, and I might want to incorporate the principles of the terms and conditions that I've seen on the, let's say, some other providers' website. So in that case, how do you go about handling that kind of a customer's request?
Mm-hmm. So we'd always take into consideration what you want and what you like, how you run your business. Like obviously, every business is going to be different. So maybe payment terms for one business A might be 14 days. This payment terms might be 30 days for business B. So there are definitely differences and kind of things that you will be specific to your particular business. If you happen to like how someone else has their, I don't know, payment terms or whatever it is, then we can definitely take that into consideration. But we won't copy. We'll draft a bespoke set of terms and conditions for you based on your specification, but we won't copy them from someone else's.
Right, I see. So there's not really much of a plagiarism involved there. I guess the question was more of, maybe, you know, I'm not a lawyer, but I do have some training in interpreting the contract. So let's say if I decide to work with a law firm, can I bring a copy of the contracts? Hey, and going back to your example of the payment terms, I'm not talking about the fillable blanks where the person could modify the number of days and whatnot, but actual like the terms and conditions that I think might be really helpful when doing the business. So in those cases, does Thackray Williams have an existing contract template that you work with a client, or do you guys start from scratch, like from the blank slate?
Basically, Laura, depends from you. I mean, you can ask us that, please, can you draft for us a term and condition? So based on our conversation, we have a conversation, we understand exactly what are your main point, and then we draft a bespoke term and condition. Or you can come to us and say, well, actually, I have a term and condition. This is my draft of the term and condition. This is what I would like to achieve. And of course, we are going to amend that draft and make it bespoke. And then again, check if for whatever reason there are some provision that they were not there. It's the same like a loan agreement. Let's say that you are a bank, you have your loan agreement in place. This is what you use usually to lend money to your clients. But then we have some banks that came to us and say, please, can you revise our loan agreement? Because I would like also to take this in consideration. Then we can review the loan agreement and actually say, well, actually, there is also this couple of clauses or provisions that we're missing that maybe can be benefit to your company. And so we discuss. So we don't expect you to know everything that needs to be in the term and condition. You basically, it's like you go to the tailor and you are doing a suit. You are going to tell me which color you want the suit, how it's going to be the design, how it's going to be maybe, I don't know, the white of the legs and so on. And then we are going to try to bespoke completely to you. Then we're going to send you the first draft. You're going to read the first draft the same way when you try the suit. And then you're going to come back to us and say, maybe you would like to adjust a little bit more this part or amend this part. So it's a kind of a work that we do together. It's not that we give you just some term and condition that we had already in our drawer and we give it to you and that's how it is. We do the bespoke. That's why you go to a lawyer. If not, you are going to have the documents already drafted and just use it.
Okay. Yeah, so we're not just drafting the document for you, but we're actually advising you based on your business and your business needs, what you're looking to achieve, how we can put that in terms and conditions to better protect your interests. So it's not just the drafting, you're also getting the advice as well.
Okay, thank you. Got silence there. Okay, Ed, is there anyone else that you can see wants to ask a question?
There's no one in the queue with their hand up at the moment. So if anyone would like to put their hands up, now's the time, as time is ticking on. No?
No. Okay, well, maybe we'll wrap it up there. You've covered an awful lot of ground, and thank you all for your questions as well, because that really helps explore the intricacies of starting off a business and the potential pitfalls. But obviously, you know, that's even more reason to have you know, good legal advisors on board. So I hope you've enjoyed today, and we've got the next one that's coming up is wills and tax planning for business owners, which is next week. So I encourage you to join that session as well if you're interested. So I think there's nothing more to say than to say thank you for coming today, and thank you to Savvy and May for your contribution, and have a good rest of the day, everyone.
I just want to let you know
for hosting us.
There's a lot of thumbs up and hearts coming up in the from the visitors, so everyone's really enjoyed it, and
thank you.
It seems like a subject that could just roll on and on. So yes, maybe want to revisit another point.
Yeah, we can
more than happy to
take
any call, and if anyone wants to have any kind of advice, they can really send us an email. They are going to find our profile on our website, and more than happy to have a one-to-one conversation.
Yeah,
fantastic.
I can vouch that they're very user-friendly as lawyers, so don't be afraid to contact them. Okay then, thank you very much, everyone. Thank you, Ed.
Thank you very much.
Thanks a lot.
Bye.
Bye.
Bye, everybody.
Bye.